We are now coming to the session under the topic the use of digital technology and artificial intelligence in company law. Thank you all participants for the presentation, for the time and effort. And I would like to call our dear colleague Tomislav Jakšić, who is moderator of this session, to join us and to start, if Tomislav is here.
Thank you.
Yeah, hi Tomislav, thank you.
I'm here and I will be leading this fourth panel titled Thematic Session, titled The Use of Digital Technology and AI in Company Law. We will be having this session for the next 2 hours. As you have maybe seen the program, you can see that we have 7 speakers, 7 topics actually, not speakers. We have much more speakers than 7. And the topic is very interesting because it tackles the impact of the technologies, new technology, especially the AI, on the traditional framework of the company law. So I would, without further ado, just to have a few grounds on rule set up. As you all know, the speakers have 15 minutes to talk, to present their research and their paper. So I will kindly ask the speakers to abide by this 15-minute time so that we have enough time at the end of the thematic session to have some maybe questions, some discussions possibly, and so forth. So without further ado, I would like to call our first speakers. This is Associate Professor Mihaela Braut-Filipović, Associate Sara Mađarov-Matijević, and Miss Morana Deničinović-Ruk. We have Mihaela and Sara coming from the Department of Commercial and Corporate Law at the Faculty of Law, University of Rijeka, and Morana is the Management Board of Adriatic Osiguranje Public Limited Company. So their topic is contractual expansion of shareholders' access to corporate information and infringement or a new model of corporate governance. So we're going to actually see in this topic what are the limits of the shareholders' right to receive information from the company and how these limits can actually be stretched and what would be the impact of such a, for example, contractual stretching of this right of the shareholders. So I would please ask the speaker or speakers to commence their presentation. Thank you.
Dear Tomislav, dear colleagues, good day to you all. It is really a pleasure to be part of this conference once again. I will start with sharing my screen, so just to be sure that technically everything is correct. Can you just confirm me if you see my presentation? Excellent. As Tomislav, you kindly introduced my colleagues, it will be, in fact, my pleasure to present to you today our research. And this year's research definitely concerns regarding the shareholders' access to corporate information. This is something which is rather plain in practice, because we all know and practitioners know that shareholders often request additional corporate information, especially requested outside of the general meeting and very often through informal channels. And in this article, we use the term corporate information, and by it we address information relating to company affairs, and which as such should include all legal and economic information concerning the company. As to our research, we limited our research to 2 types of companies, and these are joint stock companies and limited liability companies. And we approach in our research from both theoretical framework, but we also analyze a random sample of shareholders' agreements, where we in fact found that mostly this information clauses are inserted. In our paper, we analyzed many issues, but I think that for the presentation, it will be the best if I focus on our main research question only. And our main research question dealt with the question of validity of these contractual clauses under which the company or managers agreed to provide additional corporate information to a certain shareholder and sometimes even to a third party if we take into account the so-called due diligence dilemma. While you are looking at the example of the shareholders' agreement clauses which we found, let me tell you what we found more in the shareholders' agreement. We definitely regularly found clauses which provide for some additional information. And these provisions were also called information right or reporting requirements. The common feature of all of these provisions which we analyzed is that the subject who promises to deliver this information to a certain shareholder is the company and not an individual shareholder or a manager. But as managers do, of course, represent the company, then it usually is the manager who is actually providing this information. As to the content of the information, examined shareholders' agreements provided various types of information, mostly of the financial nature, such as quarter report of the managers on profit and loss accounts, balance sheets, cash flow statements and forecasts, and any other additional information on investors' requests. Of the particular interest, we found clauses, which you can read here on this slide, which provided the company shall notify the investor, shareholder of any important event that may have a material impact on the company's business, assets, operations, results of operation or financial condition, and this is the most important thing, without undue delay after any member of the management board becomes aware of such an event. Particularly troublesome, we found the clauses provide that even the copy of the minutes of the meeting of management board should be delivered to certain investor shareholders. Now, in order to try to find an answer whether such provisions are in fact an infringement or not, of course, we analyzed the Institutes for Corporate Law, and here we found two main institutes which relate to this research question. The first one is the shareholders' right to information, which we analyzed for both joint stock companies and limited liability companies. I don't think I have enough time to go into all the details regarding this very complex institute. Of course, in limited liability company, shareholders do enjoy a much greater approach to any kind of information regarding all legal affairs of the company, even outside of the general meeting. And as we all know, if you look at the joint stock company, then this right is kind of restricted only to the items that are on the agenda of the general meeting and so on. What is definitely common for both right to information regarding the joint stock company and limited liability company, that this is a mandatory provision. It means that the parties not in the articles of association, not in shareholders agreement or by any kind of agreement, they can't really limit or expand this right. So if you go a step further and look, okay, so if you have right to information institute, what comes next? What if the right to information institute doesn't provide you an answer? Where should be that limit of what should the manager give to the shareholders and information or not? We in fact found that the true answer should lie within the sphere of the duty of confidentiality, which all members of the management board have, both for joint stock companies and for limited liability companies. And here we try to find our answer. Just a remark before I go on, that the duty of confidentiality is also a mandatory provision, which means that even if all shareholders agree that they want all information and that manager is not going to be liable for any possible breach of the duty of confidentiality, of course, such any kind of such contractual clauses would be contrary to the mandatory provision and as such would not be valid. Our first step and the rather obvious conclusion when confronting the right to information and duty of confidentiality in order to find the answer on our research question is that if the management board must provide the information because the grounds for refusal are not met under the shareholder's right to information, then providing the information cannot be qualified as a breach of the duty of confidentiality. However, the answer isn't easy, of course, and what we tried is to find certain criteria to which both managers and practitioners when drafting such clauses which provide additional corporate information to a certain shareholder should abide. And within the duty of confidentiality, it is unequivocally accepted that there is a balance test, which managers should, in fact, always apply. And this is a balance between companies' interest in confidentiality versus companies' interest to disclose the information. And this test, under the business judgment rule, should be applied whenever the managers, in fact, provide information. The examples when disclosure of information could be qualified that is in the interest of the company is, for example, if the party to whom the information is being disclosed provides financial support for capital increase or other financial benefit to the company, then if it offers possible new business relationships, if it offers a know-how for business, and so on. So this is just to grasp the idea a little bit more better. When we're thinking about this balance test and our main research question, okay, if such information clauses are valid or not, let us look again at the clause and let us ask ourselves if we would interpret such clause as providing that the manager should in fact always apply this balance test in order to act within the duty of confidentiality or not. And in searching the final answer to our research question, of course, the answer isn't simple and each case should be qualified for itself. But however, what we found that should be a criteria is that drafters of the information clauses in shareholders' agreements, they should bear in mind that the manager's duty of confidentiality is a mandatory provision for both joint stock company and limited liability companies in German and in Croatian law. And managers should, for each of the disclosure, apply the test of balance of the company's interest between withholding and disclosing the confidential information. If one could interpret information clauses, such as you have the opportunity to read, as the waiver of the manager's obligation to apply the described test and favor the standpoint that the manager should just, automatically deliver the information provided the shareholders' agreement or elsewhere, authors consider that such clauses should be void as they provide for managers' obligation to act contrary to their duty of confidentiality. Vice versa, if there is enough, if such clauses are drafted in a way that we can interpret that disclosure of the information should always be done only if it is in accordance with the duty of confidentiality, then these clauses we consider should still be valid. So the drafter of information clauses should definitely know that they bear a certain risk when drafting such clauses, and managers of the company should definitely be aware of this risk, as even though there is an obligation, let's say so, written even in the Articles of Association, but more commonly in the agreement between all shareholders or just some shareholders, probably in the shareholders' agreement, which actually establish an obligation, let's say so, of the manager to give all the information to a certain shareholders. Such a clause shall not actually exclude them from their liability, as the corporate law as such as it is does insist that the duty of confidentiality and together with the right to information institute is a mandatory provision. That being said, and even if such clauses are drafted in a way that we would interpret them as to be valid, this does brings a question. Okay, has the practice moved on and the corporate law is not following the modern tendencies? Because when we look at the corporate law, it is rather clear that corporate law has already set the balance between shareholders, management, and supervisory boards regarding the access to corporate information. And even in limited liability companies, it is the managers who should know everything, who should have access to all information, and then they serve as a filter to provide this information to all other subjects, that is stakeholders regarding the company. This includes supervisory boards, and it definitely includes shareholders. So it brings us to a last thought, and that is, it is a time to actually rethink the corporate governance that we know. And what you see here are just two basic questions that popped in our mind in rethinking the corporate governance that we have it now. The first one is, should we support the power shift from management board of directors to shareholders in managing the company? This question definitely stems from the position that, although this would be a topic for further research, okay, what do shareholders actually do with all that information that they gain? Do they actually try to influence the management board? Do they actually just want to have information? Do they just, want to make an informed decision about their investment in the company and so on? We didn't go into what they actually do with all this information, but the corporate law as such as we have, even for limited liability companies, is simply construed in a way that shareholders should not have access to all this information. So what do we actually get in the practice, after all? And lastly, we ask ourselves, okay, if this right to the additional information is given to a certain shareholder, then should the equality of shareholder principle be enforced or treated as an obstacle for future development of corporate governance practices? This entire topic, in fact, stems from the interplay between the contract law and the corporate law, which once again, on this example, on this rather innocent example, if I may add, concerning all other provisions which we also found in shareholders' agreements, it definitely brings us again to face with the issue that the contract law never stops to push the boundaries of the corporate law, and in fact changing what we always talk that it is like, a basic structure for companies. So I think I succeeded to grasp all our main ideas, and I'm looking forward for any possible discussion on this topic. Thank you.
Thank you, Michaela, for this very nice and very summarized but very informing presentation on the very important topic. And I'm certain that there is a lot more to be as well discovered, researched, and elaborated upon in your future papers in this regard. So we are moving on to our next speaker. For now, just maybe write your questions down if you have anything in regards to this topic that Michaela presented on. And our next speaker is Associate Professor Zvonimir Shafranko. He from the Faculty of Economics of the University of Zagreb, who works at the Department of Business Law. And he is going to tell us something about digital data in general as a member's contribution to partnership and limited companies from the perspective of creation law. We all know that data has a value. We knew that from very beginnings of human civilization, but I have never actually seen any paper that actually doubled, at least from the perspective of the creation law, doubled or wondered what would be the impact of maybe or possibility of maybe using such data as a member's contribution into the into commercial companies. So Zvonimir, you have the floor. Thank you.
Thank you, Tomislav, for this kind introduction. Can you hear me? Okay, thank you. So I'll present some of my considerations and findings regarding the possibility to contribute the data as a member's stake to business partnerships and companies from the perspective of Croatian company law, as Tomislav already announced. Just to say, this research is still ongoing, and hopefully the results and conclusions will be delivered, and perhaps some comparative law insights as well. I will deliver them in the final paper that I'm preparing. So let me start with some numbers just to highlight the significance of data as a contemporary economic value. So according to the European Data Market Study from 2021-2023, in the EU alone, the value of data market reached 82 billion euros. That is the fact for the last year. And it is estimated that it will reach 118 billion euros by 2030, and this is only the modest scenario, while optimistic scenario, considering the further advancement in technologies, is that it could reach 145 billion euros. Then, according to some World Trade Organization reports, the global amount of data that was created in 2016 was 16.1 trillion gigabytes, while it is projected that next year it will increase to 163 trillion gigabytes. So the presented figures simply cannot leave us indifferent, especially knowing that data in the terms of transferable value and the subject of contractual transactions is barely regulated, or more often it is not regulated at all. So currently there are some principles for data economy that were developed as a joint project of American Law Institute and European Law Institute, and their purpose is to serve primarily as inspiration to the lawmakers and as a kind of model law. And of course, if someone wants, they can also use them on a contractual level as a model contract provisions that may be used within the scope of the parties' autonomy. And besides those rules, it is worth mentioning that UNCITRAL is currently developing rules on data provision contracts that will probably in some time result with adoption of another UNCITRAL model laws. So what is quite interesting about both of these instruments is that they recognize the data pools as one of the possible contractual schemes with ALI, ELI principles explicitly defining the data pools. So they define the data pools as contracts under which two or more parties that are designated as data partners undertake to share the data in the data pool by transferring particular data to a medium that is jointly controlled by the partners, or granting each other the access to particular data or the possibility to exploit these data sources. Now, if we analyze that formulation, I think we can all agree that those data pools are nothing more and nothing less than a simple form of a civil partnership. We have two or more partners. We have the members' contributions that are made in data, and of course we have the common aim, which is legit and which is consisting of access and exploitation of this joint pooled data. So this possibility raises a few questions. First, can data also be a member's contribution to business partnerships? And even further, to limited liability companies and the public limited companies. If it may, what are the conditions? And if it may not, what legislative steps needs to be taken to enable this possibility? Now, before I answer these questions, let me say something about the digital data in general. So we could simply define the digital data as interpretable information that's presented by a string of zeros and ones that is suitable for communication, interpretation, and processing. It basically means that every single phenomenon that occurs in a digital environment is de facto the digital data. Given that, for example, e-banking payments are kind of digital data transactions. Also downloading of software and music and so on. So everything that occurs, something is happening in this digital environment. So to enlighten such a comprehensive notion of digital data, in the legal theory, there are like three different types of data that are distinguished. So first, there is a functional data, which value is not in the information as such, but rather in its functionality. Perhaps the best example of functional data is digital content as provided by Digital Content and Services Directive. Such data includes computer programs, applications, audio files, games, etc. Then there is so-called representative data, which stands as a representation of some value and or some right, external value or external value, rights. So examples of such data are cryptocurrencies, transferable records, dematerialized securities, and so on. So the value of this type of data is contained not in the data itself, but in the assets they symbolize. And then there is a third type of digital data, and this type is, in fact, what I'm currently focused on. It is most interesting kind of data for my research. And this is the data that bears the valuable information per se. So it has rather intrinsic value, unlike the other two types of data I presented before. So this is, for example, personal information, data that is generated by online searches and other online activities. Then data that is generated from sensors, machines, and so on. A single piece of information that is collected that way is particularly of no value. But if we look at from the larger scale, and if we take into account how many such information is collected daily, stored, analyzed, then according to the law of big numbers, we can assume the true worth of this of such data sets. So this is something that is called big data. And the value of this big data stands in the possibilities that can be achieved by collecting, processing, altering, transmitting this data, and its exploitation for different purposes, such as predictive analytics, analysis on consumer preferences and behaviors, prices predictions, and so on. So let's go back to the company law and to the provisions of the Croatian Companies Act. And then first I will say something about the business partnerships. So Croatian law knows two, let's say, traditional types of partnerships: general and limited partnership. There's also economic interest grouping, but let's leave it aside for now. So both of these types are based on the concept of joint several liability of all or of certain members for the obligations of the partnership, and this is in fact the fundamental mechanism for the creditor's protection. So there is no minimum amount of share capital that is required when it comes to the business partnerships. However, Companies Act explicitly requires the contributions from all the partners, regardless of the liability regime that is applied to them. A member can contribute in money, things, rights, and also in work and other services and other general goods. And such a wide range of possible contributions, especially this term "other goods," I think it leaves the very open possibility that enables the members' contributions in data to a business partnerships. But when we are talking about limited liability companies and public companies, things are completely different. The liability of members is practically excluded here, and limited companies, in fact, rely on the concept of the share capital and the strict principles of its entry and maintenance as general mechanisms for the creditor's protection. Issued shares in PLC can be paid for in money or by contributing things and rights only. So there are no other kinds of contributions. Same goes for the limited liability company. So the psychology behind this is probably to ensure that the company initially generates somewhat traditional and perceptible assets which will provide the security for creditors to a certain extent. Now we can argue that the company is not liable with its share capital, but by its asset, as well as that share capital and assets may grossly differ, and perhaps with time they will, and that the structure of the assets may completely change from the very first day when the company engages into business. And there is also something that is worth mentioning, that the concept of company's liability based upon entry and preservation of a share capital became totally depreciated with the emergence of these simple limited companies and the €1 limited companies. However, the rules are quite clear about this, and today we don't have such an opportunity. But even though the reasoning for this is completely foggy, given the contemporary business trends and the environment. So to conclude this, we can say that some types of representative data, such as electronic transferable records, dematerialized securities, tokenized shares, may be regarded as a possible members' contribution to limited companies, but not because they are data, but because of what they represent, and they practically represent the right. So their value is in value that is contributed is in fact the right. And for the big data per se, it obviously cannot be regarded as a contribution. It could be perhaps pegged as a thing. For example, if the data was contained in a server and then the server was contribution, or maybe in the USB key that gives the access to this data. Or maybe it could be pegged into the claim to provide data, but this is all very, very, very slippery field. So I must say that if we look at this big data today, it definitely represents a certain economic value. It can be controlled. It is transferable and tradable good, and there are contracts that are going on for the provision of this data. And given that it complies to all general criteria to be considered as an asset, as a type of asset. However, it is not the money, it is not the thing, and it is not the right. So as far as I can say, it is impossible to, I mean, it is not permitted to invest the data as such in limited companies. So one of the possible future solutions to remove these legal obstacles is to define, to identify the data as a thing. This solution is accepted in some of the comparative laws, and this possibility is foreseen by Croatian Act on Ownership and other property rights. The other solution would consist of regulating data and data transactions from zero, from scratches, as sui generis assets, and while doing this, I think definitely those ELI principles and of course future UNSTRL rules should be taken into account. Well, as for me, I think I opt for this second option because the very nature of data and the tangible things, even though they are comparable, they still differ in so many ways and in some critical aspects. Well, I think that would be all from me. I hope I didn't exceed my time frame a lot. So I'll be open for discussion and questions at the end of the session. Thank you very much.
Thank you, Zvonimir, for your presentation. Yeah, I might have a few questions because it's a very interesting topic you mentioned, but we'll leave that for the end of this session. So we are moving on to the next session or to the next topic. My apologies. We have three colleagues, full professor Ana Poščić, associate professor Adriana Martinović, and research and teaching assistant Narda Kranetić-Blečić, which will present on the topic of the paper exploring the digitainability potential of sustainability agreements under the Commission's guidelines on horizontal cooperation agreements. These colleagues come also from the University of Rijeka, Faculty of Law, from the Department of European Public Law. As I understand, the topic will be the concept of digitainability, which is a derivative of the concept of sustainability, and it should be understood something like of how the digital technologies interplay with the sustainability goals and, of course, sustainability agreements. So I would kindly ask for the presenter to commence their presentation. Thank you.
Hello, thank you for a nice introduction, Tomislav. Today I will be presenting my presentation. First of all, I would like to thank the organizers for giving me the opportunity to be again here with so esteemed colleagues, especially to Professor Horak. And now I will just try to share and find my presentation. I think it's okay. Do you see my presentation? Okay. We heard a lot about digital technologies. Later we'll hear more on it, and about artificial intelligence. We know all that they are influencing and transforming our everyday life. There has been a constant flow of new products, services, and everything has been created by powerful new technologies, and that can possibly increase our efficiency, creativity, and of course, availability. But besides positive effects, there are some certain possible negative effects in terms of misuse of big data, as we heard before, and personal information, cartel infringements, and as well as abuse of big tech's dominant position. So there are numerous ideas how to approach to this trend we have from European level to a specific regulation. The process is so fast, it's so accelerated by those new technologies that it's so difficult to follow. But this process is sometimes referred as digital competition. And of course, we know the digital market has some special characteristics. Some of them include positive and negative spillovers, direct and indirect network effects, economies of scale, but as well as tipping and ecosystems effect. Previously mentioned tipping is, of course, a situation where all users are using only one platform. So there is a big competition for the market, but in the market it's not so intensive. But tipping is not necessarily bad, as regulatory agencies do not consider them harmful as long as they do not lead to distortion of the competitive structure of the market. Also, some firms don't have incentives to invest and invent new products and services because everyone knows that digital markets are part of multi-actor, multi-product ecosystems when the success of the market depends on their interdependency and other undertakings offering complementary products. So the balance between openness, control, trust, and innovation has to be maintained, but also a certain governance and regulation is needed. So digital markets are increasingly taking precedence over the traditional one, and their distinction has been blurred. But also, while trying to keep with the competitive edge, new companies may have struggles in maybe reaching some sustainability goals. But sustainability are closely taking part in competition, in Commission's assessment of the competition cases. At first sight, as I mentioned before, digitalization, sustainability, and competition are rather seen as completely different disciplines without any connectivity between them. But I will try to show the opposite, especially from the company's perspective, and especially after the adoption of new guidelines on the application of Article 101 of Treaty of the Functioning European Union to horizontal cooperation agreements. So digitalization may have positive as well as negative effects on sustainability. Of course, we know that the sustainability is consisted not only of economic components, but also social and environmental. But while there is only one side, great excitement, and maybe I can say hype about AI and on its economic component, on its improvement of industrialization and process, there's maybe on the other side strong concern about its effects on social and also environmental aspects. Also, we are a lot of speaking about water cooling, mining, necessary raw materials, everything that creates electronic waste, and also with large environmental footprint. But maybe before developing AI systems, maybe we can ask ourselves, is it worth the environmental cost that we will be locked in for decades? So this intersection between digitalization and sustainability has attracted more attention after 2020, when the coined concept has emerged, the concept of digitalizability. And one author, Lichtenthaler, he developed a concept according to the metrics that distinguish 4 different types of companies according to the level of digitalization and sustainability. According to it, the first category would be those companies that engage on a very limited level of sustainability and digitalization, because they are aware of the potentials of sustainability digitalization, but they are maybe more focused on financial than social and environmental aspects. The second group would cover companies that have some sustainability initiatives, but without any level of digitalization. The third would cover companies that have started to pursue some digital initiatives, like in a concept they're using new technologies in collecting, analyzing data, but maybe sustainability goals are left aside. And of course, the last one will be those companies that are focused and know about the relevance of combining both aspects. So according to this level, of course, I believe that some balanced approach is the best solution. Regarding competition law, generally, competition law is a discipline that is maybe almost passive concerning sustainability concerns. We know that competition law is promoted economic growth with more innovative products. We are consuming more products, but on the other side, it can be seen rather a paradox, because of course, more consumption, new products and services, and the resources are on the other side reduced. Of course, there's a lot of talk about greening competition, green antitrust, but also there are some crossovers between those disciplines, because we believe that we can use a competition law as a tool for maybe active promotion of competition initiatives. So it is necessary to provide some room for sustainability private initiatives or private agreements, sustainability efficient agreements in competition law. So the question is how to reconcile everything and also put everything in all these 2 things in digitalization perspectives. So a lot of researchers are exploring the way how to adjust competition rule to some sustainability initiatives. One author, Persh, for example, proposed a stricter approach, stricter enforcement of competition law. I would just recall the famous saying of Tegmark that always he said, Tegmark warns that the more intelligence the machines get, more important it is that their goals are aligned with ours. And also there are authors that propose a mindful use of digitalization in order to balance the benefits and risks of using digitalization to support sustainability initiatives. So there is a need to find any way, if this is possible, in which competition tools can be used to promote and not to discourage undertakings initiatives. So I will try to show some possible directions in which competition law and in which competition actually undertakings can promote sustainability goals, but without trying to escape competition rules. Of course, first way would be to exclude those agreements from the scope of Article 101. I just recall that Article 101 of treaty is speaking about prohibited agreements, of course, because we know that certain agreements are left aside of the scope of application. I just recall famous Albany and voters case that the voters, it was concerned with bars of agreement between bars of the Netherlands and accountants, and the court basically said that not every decision of undertakings that restricts the freedom of action of the parties necessarily falls within the ambit of Article 101, Paragraph 1. And of course, we have always another way, would be to exempt those agreements if they are found to be anti-competitive, according to the Article 101, Paragraph 3, that of course has 4 cumulative conditions for the exemptions, and all have to be fulfilled. I would just here concentrate just on the 2 of them, the one concerning improving the production or technical progress, and also ensuring that the consumer receives a fair share of the resulting benefits, because those 2, I think, in this context, I find them most difficult to prove. So the doctrine here distinguishes 2 approaches. One in recognizes in proving those 2 concepts. One will be a narrow approach that is concerned only to efficiency gains, like a reduction in cost or development of new improved products. And the other would be a more broader context. And this broad context has been in the first years of Commission's decision. I would just recall the old Commission decision that concerned washing machine cases, where the environmental topics were considered to be relevant and an issue that contributed to the improving of production or distribution of goods. But later, during the years, especially after the beginning of the modernization process later in 2004, with the first guidelines on the interpretation, then was Article 81, the Commission started to narrow down its approach and to focus only to weighing pro and anti-competitive effects of the agreement. And this approach has been further confirmed in the old guidelines from 2011 on cooperation agreements. So the second condition requires the consumer receive a fair share. And of course, here it's really important to understand the category of the consumer that is covered, because in the old cases, like this case that concerns washing machine, the definition covered the benefits not only to the consumers of this particular agreement, but also other consumers. But later this, of course, has been narrowed down. So the benefits that must be shown must be materialized and must concern the consumers of the relevant market. And of course, the question here is that the sustainability initiatives are sometimes and usually not shown at the outset. So those delayed benefits may be questionable. So, as seen for this previous discussion, there was a need to reinterpret the traditional doctrine, and new horizontal cooperation guidelines from the last year have tried to give some try to clear a Commission's position, because those guidelines now they have a separate chapter on sustainability agreements. And those also agreements, of course, will be under competition scrutiny only if they have any restriction of competition that may lead to appreciable actual or negative effect on competition. And of course, what is important to stress that guidelines cover only those agreements that trigger some competition parameters such as price, quality, choice, and innovation. So not all agreements, of course, are seen as anti-competitive. They have special subcategory of sustainability standardization agreements, and they define them as those concluded between competitors in order to provide some guidelines, rules, or, for example, to replace unsustainable products with sustainable one, or to have some special packaging or special label. Usually those agreements are not problematic, but sometimes they may be a cover for some price coordination or discrimination or price fixing or so on. Regarding the guidelines, they provide a sort of safe harbor because they say that if six cumulative conditions are fulfilled, probably those sterilization agreements will escape the prohibition of Article 101 and will not be considered anti-competitive. So it is also important to stress that, of course, if agreement doesn't fulfill those conditions, of course, it can always recall to the paragraph 3 and show that there are some contributions and the consumer has received any fair share of this benefit. Regarding those efficiency gains, there must be concrete, there must be easily verifiable. And regarding consumers, guidelines opted for broad definition consumers, so they cover also producers, wholesalers, of course, as final consumers. So the thing is that any sustainability initiative gain has to be shown to the particular consumer of the products covered by that agreement. They distinguish between individual individual benefits, collective benefits, and also indirect benefits. Regarding collective benefits, they say that they must be, in order to take them into consideration, the cover of the agreement must be significant. So the benefits must be clearly identifiable and materialize. Also, the guidelines cover the time frame. They say that as long as the time frame, the greater the benefits must be materialized. And what can we conclude? That those guidelines actually follow the Commission practice requiring full compensation for consumers. So basically, this introduction of this special category concerning and dealing with sustainability agreements is, we can say, maybe a step forward in applying more flexible approach to private initiatives directed towards sustainability gains. The idea is for those guidelines to help undertakings by giving them maybe more clarity to cooperate and to promote those initiatives. Also, I always must make a conclusion and say that those sustainability agreements, they are not any distinct category of any horizontal cooperation agreements. The agreement promoting sustainability issues can apply for this safe harbor, of course, if fulfills all the conditions, but always there is a way of applying paragraph 3 that allows us to exempt certain anti-competitive agreements. But also, what is important to stress that sustainability initiatives cannot be excused for cartels, of course. But also, of course, guidelines are soft law instrument. Although they provide a sort of safe harbor, we can think that Commission is slowly maybe loosening its position towards possible prohibited agreements. But of course, we are waiting for the first Commission decisions to maybe clear some problematic points. And maybe while we are waiting, maybe it's time for Commission to give us some informal guidance regarding some novel or unresolved questions concerning sustainability agreements. Okay, thank you all. Thank you for your attention. Of course, I'm here for any comments and questions later.
Thank you, Professor Porcic, for your presentation. And we will be moving on to the next topic. If you have any questions, I remind you, you can write the questions down so we can maybe elaborate or discuss them or have given answers at the end of the session. So the next topic is related to the paper that is written by Giuseppe Claudia Sisu and Matteo Peluso. Claudia Sisu is a corporate technology lawyer from Galgano Law Firm and a PhD candidate in business and management at the University of Turin. And Matteo Peluso is head of data in Rama Consulting SRL. So they have written the paper titled EU AI Act and Synthetic Data, New Opportunities for MarTech and EdTech Companies. The paper delves into actually questions relating to the use of the AI in marketing strategies and the interplay between the new EU AI Act and the various ethical, legal, and other governance challenges and compliance requirements established by the EU Act. So, without further ado, I call for one of the speakers to present the paper, and I please remind you to try to keep yourself to the 15-minute limit. Thank you for presentation.
Thank you. Thank you for introduction. It's an honor to present at this conference. I'm going to share the slide, and I'll ask you to confirm that you can see them. Thank you. So today I'm going to speak about the implication of European Artificial Intelligence Act and synthetic data on MarTech and AdTech companies that can be defined as industries related to the application of technologies like artificial intelligence in marketing and advertising. At first, it is necessary to differentiate artificial intelligence with respect to other kind of technologies, especially software. So we can refer on the definition provided from the Artificial Intelligence Regulation and the OECD that define artificial intelligence systems like systems that are machine-based, designed to operate with varying levels of autonomy that can exhibit adaptiveness after deployment and specifically infers capacity. So the principal characteristic of the technology that we are discussing about is that they have different kind of autonomies that show adaptiveness and the capability to infer. We are talking about a technology that shows an exponential growth in the economic field, but that can influence also social, politics, health, and other kind of sector. This technology also has some kind of technological leverage effect, especially when it's combined with other kind of technologies like metaverse, smart contract, and quantum computing that can be a technology, especially the last one, quantum computing, that can leverage the capacity of artificial intelligence to analyze and provide output. So, of course, this technology is connected to a lot of risk and critical issues, especially within the market and advertising industry. We can refer to the privacy risk, of course, the bias risk, cybersecurity, but also are growing in importance the discrimination problem and risk, and also the accountability problem. Sometimes it's not difficult to find the person that is accountable for the utilization or the output provided from the artificial intelligence system. So this is the reason why in European started several years ago a procedure to set out legislation that regulate the placement in the market, that the deployment and the use of artificial intelligence in the European Union context. So this regulation is that start its effective on August of this year is based on a risk approach. So divided the kind of artificial intelligence on the basis of the risk associated of them. So in general, we can find in such a regulation provided systems that nobody can apply or implement in the market. High risk systems characterized by several kind of obligation. Low risk system like some kind of agent, or also we can think about some general software that don't present some kind of specific risk, and general purpose AI systems that is like, for example, ChatGPT or other one famous that present the characteristic to that can be applied in a lot of different sectors. So with regard to the subjective scope, the regulation is applied on supplier, user, of course, distributor, and importer. For our purpose, specifically for the MarTech and AdTech companies, it is important to focus on some kind of prohibited systems, especially that artificial intelligence system that deploys subliminal technique beyond a person consciousness or purposefully manipulative or deceptive techniques. We can do an example applied to a marketing or advertising technology fields when we refer to ultra-personalized advertising targeting that leverage personal and behavioral data to target ADS. We can think to minor or elder people that can be more vulnerable, or we can also refer to manipulative user interfaces, dark patterns, leverage from the utilization of artificial intelligence, and also we can, of course, refer to artificial intelligence system used for targeting and that can exploit specific vulnerability features to personalize campaigns advertising. We can also think, for example, to the financial sector. If an artificial intelligence system is deployed to target a group of persons that are vulnerable with respect to their financial characteristic. Such kind of system are prohibited in the European field. Different kind of obligation are related to the AI ag risk systems. For example, we can refer to the AI system used for remote biometric identification, or a system used to evaluate the creditworthiness of a natural person or establish, for example, that credit score, or finally, the AI system used to for the recruitment for selection of a natural person. So this kind of high-risk systems are associated to really a lot of different kind of obligation. For example, it is necessary to implement in the corporation that use this kind of system a risk management system, a specific data governance, or specific features for the technical document or the record keeping and transparency, and finally some kind of the procedures associated to human oversight. There are, of course, penalties for breach of European regulation that we can see that the penalties are really specific and important also with respect to the penalties provided from the GDPR regulation. The timeline I just show you for your interest, that the timeline because the regulation entered into force in August, but it will be applied in a different timeline. But the total application will be reached in 3 years from now. Synthetic data, it's some kind of technology that is named in the AI regulation a lot of time because is a technology that refers to artificially generated data that replicates the properties, the statistical properties of real-world data, but without including sensitive or identifiable information. So it's related to the privacy-enhanced technology. Such kind of data is created by starting from real data, by processing real data through an AI model that generates a probability distribution and synthesizing new data that mirroring the original pattern and statistical property. This kind of data can be used in a lot of things and offer several opportunities, especially in marketing and advertising fields that, of course, is based on the data of the customer and can be used, for example, in AI model training. In fact, synthetic data enables training recommendation system and personalization. It can be used in AD testing that, in fact, synthetic data makes it possible to simulate user interaction to evaluate and optimize emplacement and content before deployment, and also can be used in behavioral simulation. In fact, with synthetic data, it's possible to model customer behavior, to refine segmentation and targeting in MarTech and AdTech strategy. Finally, we can conclude that the application of the regulation on artificial intelligence combined to the growing utilization and implementation of technologies such synthetic data can offer a lot of opportunities, but also is related to several obligations that impose companies to change the strategy, to change procedures, and especially to change our mind of thinking in the market. And thank you very much.
Thank you for the presentation and for keeping within the time. I appreciate that especially. So we're kind of getting back to the initial schedule. So we are moving on to our next presenter. That is Miss Eva Mišković, who will elaborate upon the topic of her paper, whose title is The Use of Digital Technology in Company Law, Essential Legal Skills for Modern Professionals. Ms. Mišković is a lawyer with almost 20 years of experience. She is a co-founder and management and partner in Mišković and Mišković law firm. Her paper deals with actually the use of digital technology and the impact of the digital technology on the traditional concepts of company law. I presume that the paper will elaborate further on the various legal skills required for legal professionals to navigate the current domain of company law with the aspect of these digital skills. So without further ado, I give the floor to Ms. Mišković, and please continue.
Hello, everyone. Thank you for joining my presentation today. Do you hear me well, and do you see my presentation? Just not Tomislav, please. Okay, thank you very much. So as Tomislav mentioned, I'm Eva Mišković. I'm a partner in a law firm that mainly provides legal services to corporate clients. And with nearly 15 or 20, who counts anymore, years of experience, I have worked extensively with companies that both utilize digital tools, but also produce them and develop digital tools. And throughout my experience, I have noticed one recurring trend that has never changed throughout the years. And that's that both of the groups often bypass legal support, whether in assessing digital tools that they are using in their for their internal use, or even in the process of development of digital tools. And this is why I've chosen this topic to bridge the gap between users and lawyers, because I found the topic even more interesting because the era we live in promises the reducement of the need of lawyers. Some tools also promise that the lawyers can be replaced entirely. While we as lawyers know that it's not true, in fact, as the technology moves on, necessity for the lawyers actually increases, but on different and higher levels. But the fact remains that many business professionals without legal background tend to view this topic differently. Yeah. So the purpose of this presentation is to point out the key risks that business can face while using and creating digital tools. And this is why the other part of the headline of this presentation is essential legal skills for modern professionals. So let's kick off with one of my favorite quotes from the author Douglas Adams. You can see it on your screen, and I would just like to add a comment that I like how it shows that our perception of technology depends of our age and experience. And when we translate this quote into business settings, we can conclude that various stakeholders from various industries have legitimately a different approach to technology, but nevertheless, all those different approaches shape the use and further development of digital tools. And this is why it has to be taken into consideration. And regardless of those differences, there is one universal truth that stands, and that is that we all have to adapt, but not to focus only on productivity, but also follow legal standards.
Ms. Mishkovic, sorry, my apologies for interrupting you. We are seeing the presentation, but we are seeing the PowerPoint window. So maybe if you can switch around to the presentation because it's not moving or something. Yeah, that would be, if it's not a problem. Thank you.
You see it now?
Yeah, we see the window of the PowerPoint application, but we probably use the full screen or something like that, but it stayed on the PowerPoint only.
Now you don't see it, or?
We can see the PowerPoint, but...
If may I intervene, you stop sharing the screen and start by sharing entire screen, not only the window of the PowerPoint app.
Sorry, I haven't done anything other than at the beginning. Just a second. So this is how you see it now.
We can see it in the PowerPoint, but you will have to switch it manually with clicks in the PowerPoint application. And you can follow it from there, yeah.
Now you see the pink one, right?
Yeah.
Okay, just please let me know if something else goes wrong. So what I meant to say that the main risks that need to be addressed are data breaches, IP risks, and compliance failures. In order to be more descriptive as possible, I have imagined this presentation as a virtual tour throughout through the departments of an imaginary company, showing how digital tools are being used and what are the most common legal and compliance risks along the way. So I would like to start from the top. From my experience, management often views the greatest benefit of digital tools in electronic signatures, because now they don't have to hand sign countless files of documentation. However, this seems to have made things easier, but it's quite complex topic because in Croatia there are rather strict standards about the level of certificate required. So, for example, Croatia accepts only qualified signature as legally valid in most of the cases, while other countries possibly have lower standards. And it's quite complicated within one jurisdiction to interpret the level of certificate, but when it comes to cross-border transactions, things can get complicated without intention, because for the sake of one e-signature, one invalid e-signature, the entire transaction can get quite complicated. Moving on to our next department, risk department. Typical risks in that department is having a tool with outdated digital environment. Further on, lack of customization in specific and highly regulated industries. And one specific risk would be lack of auditability, because if the tool doesn't allow you to check your reports and the method you used, the entire report may be unuseful, and the tool didn't help you, in fact. Moving on to HR department, I put a headline that it's holding the crown jewels. Crown jewels means employee data, and which is mostly personal data. And among those data, there are also special categories, especially defined in Article 9 of GDPR, that are data of the highest sensitivity. And in this department, two critical legal risks come together. Breaches of data security and labor law disputes. And we all know what is the significance of those two. So I don't have to mention why the tools used in HR have to be super legally checked, especially in the terms of data export, third parties, consent management, deletion practices, storage practices, etc. Moving on to project management. They are super oriented to productivity, but along the way may use the side of legality. Another interesting point is that they don't have to assess only their own tools, but also the tools used across the organization, because they at their department, entire organization meets in order to work on various projects. And there is also one interesting GDPR topic, and that's automated decision making. For example, if you have a tool that assigns tasks to specific employees based on their personal data, it could easily violate Article 22 of GDPR, because such automated decision-making needs to be transparent and needs to include human intervention as well. And for the sake of this presentation, I will finish with sales department. Those guys quite dislike lawyers, if I may say, because lawyers often involve in their deals and tend to legalize or slow things down, at least. However, while they use their templates and while they legitimately use their templates in, I don't know, easier transactions, there are usually quite complicated transactions, especially that involve IP transfers with multiple stakeholders, etc. That should, and those are the situations where templates should not be used, and where the legal help and over surveillance is quite welcomed. When we can summarize this entire virtual tour with one name or buzzword, or is it a buzzword or the next big thing? I don't know, but it's the term that you probably heard in this conference, corporate digital responsibility, and this is like a framework that tends to lead to digital justice, I may say, but this legal framework it's not a set of strict rules, and it's a framework that is how to say, presented to all of us in order to use it in the most fruitful way. I would like to finish without a conclusion, but with my own opinion, where I think we came to ironic situation in era where lawyers are proclaimed to be substitute. True digital justice will be achieved by actually involving legal support at every stage of usage or producement of digital tools. I have to mention design and development of digital tools and integration of privacy by design. Also in the process of selecting and evaluating the right tools for the organization. And finally, we need lawyers to operate and oversee the use of digital tools. Only then they will reach their goals of productivity, but keep us all within the legal framework. So this is all from me for today. I would like to thank you for your attention and wish you the nice rest of the day.
Eva, thank you very much. Indeed, I'm kind of afraid of what the future brings in this regard, because we can hear from everyday people that they are kind of using these digital tools even more and more, even in legal profession. So I can hardly see that the AI and digital tools can replace legal professionals, but they can be of significant help to us as well. But we will see what the future brings, and hopefully, I believe that strongly that the legal profession will survive. Thank you, Eva.
Thank you, Thomas, for your comment.
And we are now moving on to the next topic from our next speaker and presenter, Mr. Ivan Romaschenko. He is a Max Weber Fellow at the European University Institute, and the topic of his paper is verification of shareholders using digital technologies in the Baltic states, a comparative perspective. Well, we all know that COVID-19 changed a lot in regard to the use of the online general meetings in commercial companies. And it kind of brought and demonstrated a lot of challenges in this regard as well, at least from the perspective of the Croatian legal system. We all know that up until recently, the legal situation was that such digital systems had to provide verification of the person that is participating, a shareholder, for example, so that the entity could be without any doubt ascertained that he's enabled to participate. The system has to actually also enable communication and active participation, and of course live transmission of the general meeting. So I'm kind of looking forward to hear what's the perspective in the Baltic states. So Mr. Romaschenko, you have the floor. Thank you.
Thank you very much for the very nice introduction, and to the organizers for the excellent organization of the conference, to Professor Hanna Horak. And now I would like to share my presentation. Can you see my presentation now?
Yeah, we can see it.
Okay, great. Great. So first of all, this is my research as a Max Weber Fellow and at the European University Institute. But this month I started another position at the Maria Curie Skłodowska Youth Postdoctoral Researcher at the University of Cyprus. So that's why I have a double affiliation. So first of all, I would like to start with a short outline of my presentation. I'm going to briefly go into the area about verification of shareholders and in general electronic verification. Then I will describe my research agenda and move to the core of my research as far as the law on the electronic verification is concerned, and we'll then describe the results of cases analysis, and we'll conclude with some findings and recommendations. So as you all know, the issue of electronic verification is not unique for corporate governance. In many areas, we interact by technologies, and it is true, as you mentioned, Tomislav, in the introduction, that during the COVID it has intensified, and post-COVID showed that it became a new normal for our everyday life. So it's not only about corporate governance. And one of the main issues which arises in electronic participation is to know that the persons to whom we are talking electronically are the ones who they claim to be. So that is why the issue of electronic verification is very important. And there are several ways how to electronically verify individuals, such as the verification by credentials, through documents, or facial recognition verification, or also there is the way to verify individuals by password. So I was curious about this topic, and I was willing to find some successful cases of electronic verification in European companies. To find these cases, I took the report of the European Commission on the digitalization of public services in European countries, and I found out that Baltic states are among the front runners in digitalizing their public services, and that's why I decided to find these successful cases of electronic participation, electronic verification of shareholders in the listed companies in the Baltic states. That is why my goal in this research was to examine the experience of electronic verification of shareholders in selected listed companies in the Baltic states during general meetings, which were held from 2021 to 2024, so starting in the middle of COVID and the post-COVID period, and to analyze some relevant laws in this area and to propose recommendations for improving existing regulations and practices. The research question which I posed was whether the verification process for shareholders' electronic participation in company general meetings is compliant with the current laws and standards. So to move to the core of my research, I basically outlined that, well, there is one act which is quite well known in European company law, is the Shareholder Rights Directive. Article 8 of the Shareholder Rights Directive allows, it mandates member states to allow shareholders in listed companies to participate electronically in general meetings. And all the member states already have implemented this requirement, including Baltic states. And it's in the Baltic states, basically the regulation mirrors the rule in the directive. It's basically gives the companies the right to self-regulate these relations as they see them do. And I also ask myself whether human rights are anyhow involved in these relations, and we can say that as shareholders send some personal information to the company for the verification, there is some relation to the right to private life, because this is a very broad life, as a broad right as identified by the European Court of Human Rights. But of course, it's very arguable to say that there can be a violation of this right by the company, because these are horizontal relations and the states are not involved. So, as I said, there is some flow of information, and we can also say that the GDPR is somehow here is touched upon. But it's important to consider that it's not identification of individuals, because companies that verify shareholders or their representatives for the electronic participation, they already possess the data. So, but still there is some flow of data, and that's why I think that the GDPR can be also involved here. And if in case the facial recognition technology was used, it would also trigger the application of the EU AI Act and other acts on artificial intelligence, but the spoiler, there was no case of facial recognition technology usage by these companies. So when I tried to find these companies, I accessed public information on Nasdaq Baltic.com to find these listed companies, and basically my idea was to find one company by member state. So I have selected one company from Estonia, ECLCG Group, one from Latvia, AS Amber Latvias Balzams, and from Lithuania, Snaigė AB. So having studied the public information or about general meetings in these companies from 2021 to 2024, I revealed the following results. And first of all, we can see that companies use different platforms for electronic participation. Usually it's Microsoft Teams, but some companies like Estonian company used a special electronic environment, or sometimes companies did not disclose the platform in advance. Maybe just they said they disclosed it very shortly before the meeting, but otherwise it was not disclosed. As for the verification methods, all companies use credential-based verification based on documents. Snaigė AB used a password knowledge-based verification when a password was sent to a shareholder, and then the shareholder told this password through camera and microphone. And ECLCG Group from Estonia used digital signature verification, which is quite reliable. It's considered quite a reliable tool for verification. In terms of timing and duration of electronic verification, it usually started 1 hour before the meeting and lasted 30 to 45 minutes, depending on the company. There were notable divergences in terms of how companies approach the privacy and personal data protection issues. I have to say that Estonian company was most elaborate on this because they published a separate document where all kinds of personal data were that were collected by the company were published, and also the rights of shareholders. So I think it was, from the transparency point of view, it was a best practice approach. And there was also an interesting issue of the verifier, because for Latvian and Lithuanian companies where verification was by video and microphone, there was a person of verifier who was the director of the company. In general, I think the director it was a good solution, but it's important to, of course, to consider the conflicts of interest, the potential conflicts of interest that can arise with this person. Because, for instance, if there is a conflict between the management and some minority shareholders, maybe the person who is a verifier, who is close to the management, might abuse its position. But here, I didn't see anything of like this. But still, I think it's important to consider this. And as I said, AI was not used for the verification, and there were some other issues I think are worth considering, such as troubleshooting. Snaigė AB, the Lithuanian company, for instance, indicated the implications in case there are some technical problems, that the meeting can be suspended for the next day. And also other issues that are worth considering, and it relates also to the previous presentation, which is the digital skills and the accessibility, because the companies need to pay more attention to how persons with low digital skills, reduced digital skills, whether they can access the meeting. And so moving to the conclusions and recommendations, first of all, in terms of the regulation, this area is primarily self-regulated by companies. And so there's a question then, whether states or the EU authorities have to intervene to establish some level playing field with clear standardized rules. In my opinion, it is better to have guidelines, just guidelines for companies, because in terms of even within the Baltic region, companies have different practices, and some companies, depending on the number of shareholders, they prefer to have one platform, and other companies use some other platform. So I think soft law regulations or guidelines is the best option. In terms of my recommendations based on this research to companies, it is good to improve the clarity and transparency on platforms in participation, personal data processing. As I said, the Estonian case was quite impressive for me. Troubleshooting procedures, and it was the Lithuanian case where they indicated some troubleshooting implications, and that was a good practice as well. I think also that companies should ensure an effortless process for individuals with disabilities and limited digital skills. They can provide for counseling and upload demo presentations of how to access general meetings. So this is the recommendation. And finally, it is based on the research, I recommend to allow sufficient time for verification to ensure the verifier impartiality, and to consider facial recognition technology as an optional enhancement. I have to say that it's facial recognition technology is not panacea. It's also not fraud proof, but as an additional layer of protection, it can be used, I think, in a positive way. So actually, this concludes my presentation. It's just an acknowledgement slide. So I thank you, and in case you have any questions, I will be glad to answer them.
Thank you for the presentation. We are all aware that today public limited companies listed at the stock exchanges, at the regulated markets, are actually trying to bring back shareholders back to the company. And one of the ways to try to do this is to introduce this kind of technologies, use them to help companies to have more shareholders present at the shareholders meetings. Thank you. And we are now moving on to the next and the last but not the least presenter, Associate Professor Jelena Lepetic from the University of Belgrade, Faculty of Law, where she teaches company law. The topic of professor's lecture presentation is gender balance among directors in the age of AI. We are all aware that the EU recently, it took a long time to adopt the EU directive improving the gender equality in the management of the companies. But the paper kind of and the presentation, as I understand, will take a step more in direction to try to explain and give us an insight into how the development of the AI could influence the gender balance in the corporate boards. So, Professor Lepetic, you have the floor. Thank you.
Thank you, Professor Jakšić. It is my pleasure to be part of this conference. And I would like to congratulate the organizers, especially to Professor Hannah Horak and her associates, for organizing this wonderful and thought-provoking event. So my idea was to deal with the intersection of the development of AI and its influence on corporate boards, director, and especially the gender balance among the directors. So both of these topics are highly debated and very hot topics, but the intersection and overlap between them not as much as it should be, under my opinion. So to start with, I need to clarify that there are various mechanisms which are used to foster gender balance. But the most popular ones, and the ones which are used, for example, in the EU and also in Serbia, are quotas. Beside these instruments, there are many others, such as, for example, reporting, creating a pool of candidates of underrepresented gender, and so on. But quotas are very interesting from the company law perspective because they may be understood as modification of shareholders' rights. And the intrusion of these quotas to company law is of highest intensity when these quotas are provided for appointment of executive directors, but also for appointment and election of non-executive directors. I will not speak about the motivations, the motives of legislators to impose these quotas on companies, because we have seen that there are so many arguments which are mentioned as good motives to do this, but the empirical studies, they showed very diverse results. For example, regarding the financial performance of companies, there is no clear link between the quotas and the improvement of financial performance. So legislators are definitely ready to introduce quotas for other reasons, such as ethical reasons, for societal goals in general. So in 2022, the Gender Balance Directive was adopted in the EU law, and this directive was adopted 10 years after the publication of the proposal for this directive from 2012. So we can see, because there is a difference of 10 years, that it was not easy to make this happen. So what is important from the company law perspective is that Gender Balance Directive does not harmonize rules on selection and appointment of directors. So it does not set the rules regarding the general meeting of shareholders and their selection of the directors, but it sets only minimal requirements regarding this process in listed companies, regardless of its system of board structures. So what are the quotas in this directive? First of all, members of underrepresented sex have to hold at least 40% of non-executive directors by June 2026, or at least 33% of all director positions by the same date. So this number should be closer to the set proportions, but not exceeding 49%. These companies may also set individual quantitative objectives with a view to improving the gender balance among executive directors, which should be achieved by 30 June, so the same date of 2026. Those are the companies which are not subject to this objective. But the shortcoming of this directive is that these rules may be suspended by the member states. So there are two alternative requirements which should be met in order for the state to suspend these rules. The first option is that until the 27th December 2022, the members of the underrepresented sex hold at least 30% of non-executive director positions, or at least 25% of all directive positions. So you may see that these percentages are lower than the ones that mentioned before. Also, member states' national law may require those proportions and require that it is included that the measures which should enforce these proportions are effective, proportionate, and dissuasive. For the cases of non-compliance, and it may require that all listed companies which are not covered by that national law set individual quantitative objectives for all director positions. So these are two alternative mechanisms. These are not, of course, the only rules which are set by the directive. I will just mention that an important rule regarding the selection process, which is provided for in the directive, is the rule on positive action, which means that the priority should be given to the underrepresented sex in the selection process. There are also rules on the reporting obligations. There are also rules regarding the penalties, but I will try to be efficient and just I will leave this to you to read it in my final paper. So let me now present some statistics to see where we stand. The source for this data is the European Institute for Gender Equality. It is important to emphasize that these data refer only to the largest listed companies in EU. So you may see that the total number of women who are board members is more than 33, almost 34% in 2023. And it was much lower in 2013, so 10 years before, when it was 17.8%. The numbers of women presidents and also women who are CEOs are much lower. So, for example, you can see that it is 8.3 in 2023 for women presidents and 7.08 for CEOs who were women in 2023. But still, these numbers are much increased compared to the period on 2013. And I also provided the data for a few years in a row just to see what is actually happening in the EU member states. Also, it was, as expected, the number of women who are non-executive directors is higher than the women who are executive directors in total among the EU member states. And now a few words about the fostering gender equality in Serbia. So in 2021, in Serbia, the law on gender equality was adopted. But all the individual measures which are implemented in accordance with this law are now suspended because the Constitutional Court of the Republic of Serbia has instituted proceeding of assessing the constitutionality of the law on gender equality. This happened because there were 8 initiatives to do that because of the differences between the notions of gender and sex. And I should also emphasize that when you read the EU gender directive, gender balance directive, you will also see that in the directive, the notion which is used is sex and not the gender. So all the quotas which are related to the corporate boards are actually binary. So they are related to men and women and not to the issue of gender, which is quite different these days. So in Serbia, this law affects both state-owned companies and private companies. And it also provides for the rules on special measures which should be undertaken in the cases of significantly unbalanced representation of one of the sexes, which means that that sex representation is below 40% compared to the other sex. So the idea of the law on gender equality is the same as in the EU Gender Balance Directive, and it uses quotas as a main mechanism for fostering gender equality in corporate boards. But again, there is one shortcoming of these provisions, is that it does not stipulate sanctions for non-compliance with this requirement. So this means that the prescribed quotas are only voluntary, but this is not the case for other mechanisms for achieving gender equality. In the other cases, there is a penalty, which is a fine for misdemeanor. And now some statistics from the Statistical Office of the Statistical Office of Republic of Serbia and Business Register Agency, just to show what is the state in Serbia regarding the women directors and percent of women who are directors these days in Serbia. So we will see that total number of women directors. So here, these data refer to all the companies and not only to the largest listed companies. They show that there is 25.3% of women directors in 2023, And it was no great change till 2019, from 2019 till today regarding this. It is a better percentage with regard to the supervisory boards, because as of first March, this is the newest data from the Business Register Agency, this percent was 30.2. But when we look at these data, we should know that women comprise the majority of the population in Serbia, and also they made up 59% of enrolled students and 50 and 61% of graduates in higher education institutions, which is quite similar to the statistics in the EU. But now, let me also share some statistic, only some basic one for the largest listed companies, again, in Serbia. And this statistic is very surprising. So it is worse than the statistic for the companies in total. The total number of women who are board members of these largest listed companies is only 18.2%. So for the largest companies, representation of a woman is lower. And also, interestingly, the best results are achieved for the women who are executive directors and not non-executive directors. That's why I wanted to present it, because it is quite unusual. Also, good results are shown with women who are CEOs. For example, there are 22.2 CEO women in 2023 in largest listed companies in Serbia. And now I would like to shed some light on the influence of AI on gender equality and all the effort and on all the efforts of the legislators regarding achieving the gender equality in the corporate boards. So these mechanisms should definitely be reviewed from the perspective which includes the development of AI. So AI may be an important tool both for fostering and impediment to fostering gender balance. But what is good to know is that AI Act also gives some insights and help to prevent the negative effects of using the AI development on this topic. I would like now to differentiate three different scenarios regarding the AI and corporate board. So first of all, the AI may be used when selecting director candidates. That's one particular field of this potential influence of the development of AI. The second one is the appointment of AI as a director. And now, again, here you can have two different scenarios. If the software is only director in the company, then gender balance does not exist, because only the software is the director. Here, at this moment, we don't have such boards of directors, because actually it would be one director. I am not sure that there would be any need for appointment of 2 or 3 softwares as directors. So the relevant scenario for present case is the scenario of hybrid boards. Boards consisted of both directors and softwares. And here you have many problems. First of all, if the software is recognized as the legal person, we don't know how we can count quotas in this regard. This is also the problem for the gender balance directive in general, because in many countries of the EU and also in Serbia, which is the third country for this perspective, legal persons can be nominated and be appointed as directors. So we don't know how to apply quota for this scenario. So this is important. And also, which directors in this scenario will be replaced by algorithms? There are some actually empirical studies, but US studies, which show that it is likely that independent directors will be mostly replaced by these softwares. And we know that in general, independent directors may be women. And it is more likely that they will be women, because we know that non-executive directors of course, are the type of directors which is played by women generally in this content of gender balance. And finally, the third, the most extreme scenario is that you don't have directors at all. And we now have that in DAOs, which are specific types of organizations, you don't have directors. So there is no gender balance. Definitely, which I may conclude, is that AI will influence the issue of gender balance among directors. So first of all, and I will conclude with it, the good thing is that for the topic which includes selection of women directors, AI may help. And it's good to know that AI Act recognized AI system which is used for recruitment of humans and therefore for directors also as a high risk system. So there are many requirements which need to be analyzed regarding the potential of the using of AI system for recruitment of the directors as well. But I will not speak about that because we also heard something from Professor Sisu. I will just say that this system is one of these. The recruitment definitely is a high-risk AI system. So I will conclude with this, that AI development is definitely relevant for board composition in several ways. That AI can influence the candidate selection process both positively because it can widen the pool of the candidates who may be considered for the appointment, but also negatively because it may lead to the discrimination, to the non-fairness, unfairness, to the discrimination, and it may negatively affect diversity also. But we have these rules from the AI Act which should prevent these negative effects when using AI for recruitment of directors. And also, directors may be replaced by software, and this may definitely negatively affect gender balance in boards. For example, the number of board positions will be lower, and there is no place to appoint new women in that scenario. And also, as I said, also especially if you have a scenario where there are no hybrid boards but only software boards, there is no place for gender balance as well in the scenario where there are no directors in the company, which also exists today. So those will be my conclusions. If you have any questions, I will be happy to answer it. And also, if you can write to me, here is my email. Thank you.
Thank you, Professor Lepetic, for your presentation. So although we have reached our time allotted for this session, I'm going to ask if there are any questions, maybe for any of the presenters on any of the topics presented in this fourth session. Anyone, please? Is that Mate who is trying to ask a question? Yeah.
Yes, I do. I have a question for Ms. Iva Mišković relating to digitalization in corporate law. Now, my question is, how exactly can we befriend two very opposing problems? One, we have archaic regulation using very archaic terminology, and we have modern tools at our disposal, which means that sometimes the regulation that is in place doesn't even take into consideration the modern tools at our disposal. How exactly can we bridge that gap and not saying that we have to change the acts that are archaic?
Thank you for your question, Mate. It's a commonly used statement that regulation beats creation. And I, as a lawyer, am not a fan of legalizing and over regulating, especially new industries, especially digital industries that are evolving faster than predicted, and legal regulation cannot keep track with them. I would say that a solution lays in something that I have experienced through my career. I began working with IT companies since Croatian IT scene, as we know it today, was at their beginnings, and there was big how to say, there was quite stakeholders in that IT scenes didn't accept legal advices because they thought it will beat their creation and that they will slow them down. On the other hand, during the time and during their development as companies, they accept legal support, and they are actively seeking for the legal support because they have become aware of it. So, for the question of regulation, I would say that we have enough legal concept and framework to define general principles how to act. We don't need strict and over-regulated laws, but we need like general framework, and we need stakeholders that are well informed what are the risks, and having that in mind, they will always keep their business within the frames of general rules that keep their business safe and that keep other stakeholders safe, and still allow their tools to obtain productivity we are all looking for. So to conclude, in my opinion, we don't need more and strict regulation. We need more awareness and just to follow the general framework that is quite enough already.
Thank you.
Thank you for the question.
Thank you, Mate. Thank you, Eva. Do we have maybe some other questions from other participants? Yes, I think I can conclude that that there are no questions. So just to shortly conclude this session, we have seen throughout the topics presented that we have mostly heard how digital technologies might help us, but we have also heard about some concerns which are coming hand in hand with the digital technologies, their use. All this demonstrates that legal field is always in motion. There is actually no rest, and we as legal professionals must be vigilant and mindful of the new technologies coming into the legal playing field. But we also must be creative in their and can be creative in their everyday application. But the interplay between various legal fields is as we can see, always in commotion, meaning that various legal fields also clash with each other even more so than before. But generally speaking, I want to say that we cannot relax if we want to remain in touch with the law and such new tendencies. But hopefully, digital technologies will prove to be a valuable tool in our profession and not a device that will make us obsolete, so to speak. So I thank you all for participating. And well, as I understand, we have one more session. We have a break now from now until 2:30, and then we have the final thematic session. Thank you all, and well, see you in the next session.